Education Committee. My other co-chair back there is Kirby. Can I have the members of the committee please raise their hand to put this together? All right. Thank you. Can we give them a round of applause? Thank you. All right. This is the first workshop in this series, so we hope everybody comes back for the next ones. We have 4 over the course of April and May, and I'll speak to that more later. But we have tonight speaking for us or giving a training on tenant rights. Her name's Paula Green, and she's with Legal Services. And so I will give you her so you guys can learn more.
It's a little further from that table here. Did you? My name's Paula Green. I'm an attorney. I'm a senior attorney at Legal Services. My practice area is primarily in housing issues, particularly landlord-tenant issues. So we're going to talk today. The goal of my presentation is just to give you an overview of the nuts and the bolts, the landlord-tenant law 101, if you will. Mostly so that you will be armed with the information you need, not so much to advocate for yourself in court, but more to identify issues and maybe times when you need to reach out for legal services. So here's our contact information. I do have handouts at the desk that have all of these slides. So if you miss something on the slide, you can just grab one of those handouts and it'll be there. Here we go. Okay, housekeeping. Turn your phones off if you can, or on vibrate. If you need to leave the room, go right ahead. I'm not too picky. As far as questions, if you have a question during the presentation, just go ahead and raise your hand. It's probably going to be more beneficial if we address questions as they come up. But don't be surprised if I say, hold on, we're getting there, okay? All right. The 3 things I want you to take away with you before you leave is that your landlord must take you to court to remove you from the property. Number 2, always designate your rent payments as rent and get a receipt, always. And 3, never sign a contract with blank spaces in it. We're going to take each one of these throughout the presentation. There we go. Okay, so Missouri landlord, the relationship between tenants and landlords. First, we're going to talk about how the relationship starts. Oral leases. Oral leases are just what they sound like. It's a verbal agreement between you and the property owner. They're perfectly legal. They're perfectly enforceable. There's no handshake is necessary. All you have to do is have an agreement, an understanding, or a meeting of the mind of the identity of the property and how much you're going to pay. And with that, you've got an oral lease. The problem with oral leases is when you have kind of strange or unusual terms as part of the agreement. Anything that you guys don't specifically address as part of the oral agreement, the state law is going to fill in the gaps. Okay? This clicker is kind of slow. There we go. Wait, I went too far. Okay, hold on. This fancy technology is a little bit much for me. I think my slides are out of order. Okay, written leases. Written leases are exactly what they sound like. They're leases that are written down. There is no such thing as a uniform lease. A lease can include just the most basic terms. A written lease can be 20 pages long. A written lease can be on a napkin, and I've actually slapped an exhibit sticker on a napkin and offered it up in court. So, if it's in writing, it's a written lease. The thing I want you to remember about written leases is never sign one that has a blank space in it. Now, you would think that the daughter of a lawyer who practices in landlord-tenant law would know this, and would not sign a lease while she's in college with blank spaces. Now, I'm not gonna say exactly who did that, but Mama had a problem she had to deal with a year later when the lease ended, and there was a blank term when she signed it, and that term was not, that space was not blank when the lease was over. So, you know, if you ever come across a lease that they ask you to sign, and there is a blank, what I want you to do is make sure to make some mark to, you know, right through that blank to indicate that when you signed it, there was no detail or information put in that blank space. Written leases are great, if you have unusual terms, like for example, that you're leasing this property, but the landlord retains the right to, use and possess the garage, you know, something like that. Anything beyond just, I've got this property and I'm gonna pay this much money, it's good to have that in writing. Again, if your lease doesn't address it, state law will fill in the gaps of anything you guys didn't address in the lease. Now, okay, illegal or prohibited terms. Sometimes landlords put in terms in their lease that are prohibited or illegal. What the court does with those is just ignores them, it's like they weren't there. One illegal term is, if, and I see this all the time, the landlord will put in that the tenant waives any warranties implied or otherwise to the property. And we're gonna touch on some of these warranties that you get as a tenant by state law, but that waiver, it's like it wasn't there. Now, this is an example of an illegal contract. I can get to it. Oh no, I went too far. Emily, do you think we could do something different than the clicker? Yeah.
Can we do manually? We can do it manually.
And sometimes it's still going backwards. Okay, now we're going, we almost had it. Okay.
Here?
This is my favorite illegal contract.
Just let me know and I'll change it.
Okay, so if, let's say that I was presented with this contract, I, Paula Green, will sell my children to Joe Hills, my good friend at Legal Services, who will own them free and clear. Joe will he'll pay me, we're gonna say maybe 25 cents a pound for my boys. The daughter who signed the lease with the blank spaces, she's maybe 15 cents a pound. Per pound for my children, and we sign it. This is an illegal contract. The court's gonna completely ignore it. Okay, could you advance it?
Yep.
Alright, so leases often, include a security deposit, requirement. Things you need to know about security deposits is by law, they can only demand that you pay, a security deposit that's equal to no more than 2 months worth of rent. The security deposit covers almost, all of the monies that are paid to the landlord. Pet deposits are different. Pet deposits can be non-refundable, but otherwise, your leases should be, your security deposits are refundable, and we'll talk more about security deposits in a second, if we advance it. Now, after you've gotten into the relationship, let's talk about how it works. Most important part of any lease, oral or written, is of course the obligation to pay rent. Now you remember one of your takeaways is always designate your payment as rent, and get a receipt. Handwritten receipts are perfectly acceptable. If you're paying in cash, then you want some kind of proof that you actually made the payment. If you pay in cash or money order, you really need a separate writing that you can keep as a receipt. If you're paying with a check or paying electronically, that check can become a receipt when you get it back through your bank and it shows that it was deposited. So the whole purpose of a receipt is just to have some proof that you actually made the payment and when you made the payment. But you also want, along with your payment, you want to have it designated as rent as opposed to just a payment. You can do this by, when you give the money, communicating to your landlord, this is my April rent, or you can write it on my preferred method is to write it on the payment itself. So if you do a check, you write April rent on the check. If you do it by money order, you can write on the check April rent. I would recommend you take a picture of the money order before you give it over. If you're doing it in cash, you can slip a note in with the cash. If you're doing it by an electronic transfer, most transfers have a memo line. I would write April rent in the memo line. The landlord is not required to take partial rental payments. They can, but a partial payment doesn't satisfy your obligation to pay the rent. I don't think I explained why writing rent was so important. That's part of one of your takeaways. The reason why writing the word rent on your payment is because in Missouri, when you owe somebody money, you as the debtor, you have the right to designate what that money is gonna go to. If you don't, then the person who you owe the money to, the creditor, can decide how to allocate your funds. Now, why that's important with rent is because sometimes the landlord will assess fees or other charges that you maybe aren't aware of. And so what happens is, I'm gonna use nice round numbers here, but let's say your rent is $500 and you're paying $500 every month. And you keep reducing your balance back down to zero. Well, let's say that for the month of April, the landlord imposes a fee because you didn't, take your trash bins back in like you were supposed to, and they're allowed to charge you a fee for something like that. And either you've forgotten about it or you weren't aware of it. So then when May comes, you've paid them $500. They can take a chunk of that $500 to pay that fee. So let's say the fee is $50. So they'll take $50 to pay the fee and then apply $450 to your rent. So you're now behind on rent by $50. So when the late payment date comes, many leases say if you haven't paid by the 5th, then we'll apply a late fee. So the 5th comes and they'll add a late fee onto that. So now the next month when you pay your $500, they're gonna take a chunk of that money and they're gonna pay the April rent, and then they're gonna pay the late fee, and they're gonna take, say, the $350 left over and apply that to May rent. Well, now you're $150 behind. This becomes significant because in a rent in possession action, which we're gonna talk about in a bit, but the landlord can only take possession of the property back if you're behind on rent, not if you're behind on fees. So for it sounds like it's an accounting thing, but it really has a significant, substantive. Why is this going off? Yeah, there we go. So it does have a significant substantive effect on your right to maintain possession of the property, how you designate your money's going into the landlord. Okay, so now, this is a question I'm hit with all the time, which is, can you withhold payment of rent to make repairs? The short answer is generally no. In a very limited circumstance, you can, and that is, there is a statute that says you can withhold rent to make repairs if you meet all of these criteria. The first is that the condition you're wanting to repair has to fix a condition that, or the condition has to detrimentally affect the habitability, sanitation, or security of the premises, and it has has to be in direct violation of an applicable housing code. So, you know, in Springfield, we've got a pretty robust housing code. Outside of Springfield, in some communities where they don't have housing codes, this won't even apply. The second condition is that you can only withhold $300 or less to fix the condition, and the amount you withhold, can only total, can only total an amount equal to 1/2 of a month's rent over a 12-month period. So if you have to withhold multiple times, the amount you withhold can't exceed 1/2 a month's rent. So this really has very, very, very little teeth to it. Go ahead and advance. Before you can even do it, you have to have lived in the property for 6 months. You can't have any unpaid rent for the last 6 months, and you can't have any lease violations. In order to do it, you have to first notify your landlord of the condition in writing. And whenever I tell you to do something in writing, always keep a copy of what you've done for your own records. You can do that by just taking a picture of it before you give the writing to your landlord. You have to give your landlord 14 days to respond. And then, if your landlord doesn't fix it within 14 days, you can do the repairs. And then when you pay your rent and withhold your costs, then in addition to whatever rent, then you have to provide the receipts or the itemized statements that show, you know, the balance of what you withheld. Go ahead. Now, if your landlord, in those 14 days, if they dispute the need for the repair, then you can't make the deduction. So, there you go. Typically, this is, it's not invoked very often because, the repairs are usually so small and the conditions for allowing you to make the withholding are so strict that it's probably better to pursue this as a habitability issue, which we'll get to in a minute. Go ahead. We're gonna get to it right now. So one of the warranties that you have in Missouri as a tenant is the warranty, it's an implied warranty of habitability. It's implied because it doesn't have to be in writing. Whenever a landlord leases property, residential property, and it only applies to residential property, regardless of the nature of the property, whether it's a house, apartment, trailer, whatever. It comes along with the law, implies the promise from the landlord to the tenant that this property is fit for human habitation. That's a very low standard, by the way, but that it's fit for humans to live in. We look at, you know, what defines what is fit for humans to live in. We can look to local housing codes as evidence of where that line is, but then we also look at local standards. For example, right now in Missouri, having working air conditioning is not considered a habitability issue. In Arizona, where, you know, the temperatures get so much hotter than here, it would be. So, yeah, so that's kind of how we set the standard. The best way to look at it is there a condition of the property that puts the health or safety of the people inside the building at risk? So sanitation issues, you know, sewage issues, lack of running water, holes in the roof, holes in the floor, doors that don't lock, anything that puts somebody at risk if they're living there could be a breach of the implied warranty of habitability. We call it a shield and a sword because if you're sued for rent and possession, you can raise, you know, where your landlord says, hey, you're $1,000 behind on your rent. We can raise this as an affirmative defense to say, well, we're not behind by $1,000 because the damages you owe to the tenant is greater than what the tenant owes you in rent. That's the shield. It's a defense to a rent and possession action. It's also a sword because we can actually initiate our own action, our own lawsuit against the landlord to recover damages for breach of the implied warranty of habitability. Next slide. Another consideration that we have is constructive eviction. That's where the conditions of the property are so bad that you have to leave. The conditions are, they don't have to be putting your health and your safety, you don't have to prove a physical danger like you do with breach of implied warranty of habitability. You just have to show the conditions are so bad that you can't, nobody can live there anymore. Now, to claim constructive eviction has occurred, you have to actually leave the property and you have to take your stuff with you. You have to fully abandon the property. If your stuff is still there, you're still there. Constructive eviction is only a defense when the landlord has sued you for unpaid rent or for breach of the lease. So if you've moved out because the pipes are making such a terrible racket that you can't sleep at night, makes the property unlivable, you have no choice but to leave, you can break your lease. If your landlord tries to sue you over that, you could raise constructive eviction as a defense to that lawsuit. That's why we call it a shield only. You can't sue for constructive eviction. Your only recourse is to leave. It does relieve you from having the obligation to pay any rent after you left, though. Okay, so that's how the relationship starts, how it moves along. Now let's talk about how it ends. When you move out, take as many pictures as you can of as many surfaces and areas as you can, so that you have proof of the condition when you turn the key in. I can't emphasize that enough. Once you've moved out, you have the right to be present when the landlord does the inspection. They have to notify when they're gonna do the inspection. You have the right to be there, but you're not required to. When you moved in, if they gave you a move-in checklist where you mark all the stuff, all the defects that you see, it's handy to have that with you. Next slide. Oops. Here's the reason why, because I told you we're gonna get back to security deposits. The point of the move-out inspection is to determine whether the landlord has the right to withhold anything from your security deposit. Under Missouri law, a tenant is entitled to return of their security deposit within 30 days of the date that they move out, less any deductions for damage that is attributable to the tenant, to the property. They can only deduct from your deposit for damage that was caused by you or your guests, so not damage because of negligence by the landlord, but by you, and only for damage that exceeds what we consider normal wear and tear. So if you've lived in a place for 15 years, brand new carpet when you moved in, and 15 years later you move out and the carpet looks worn, they can't charge you for replacing and putting in fresh new carpet. That's normal wear and tear. Alternatively, if you move in and you spilled grape soda by the front door and there's a big stain, they can charge you for that, right? They have to, when they return their deposit, if they've deducted anything from it, they have to give you an itemized statement of what every deduction was for. And they can only deduct for the actual or the reasonable cost of the repair. They can't inflate prices unless in the lease, you wanna check, some leases have an itemized list of charges upon move out. So they have a standard fee for, if they have to replace blinds, the blinds are gonna be X number of dollars. The court's gonna hold you to those numbers, if you've agreed to them in advance. Otherwise, we look at actual or reasonable value of repair. Now, if your landlord doesn't give you your deposit back or doesn't provide you with this itemized statement, you can sue, and the court is required to give you two times of the amount that was wrongfully withheld. Which we do. That's something that legal services will do. It mostly as, kind of a chain yanker on the landlords who are withholding deposits just because they think they can get away with it. So there is a little bit of a punitive measure in there. Now, on the flip side, if the damage to the apartment costs more to repair than your security deposit, your landlord has the right to sue you for the additional damage. Next slide. Now let's talk about when the relationship goes bad. So evictions, that's the big scary word. In order to remove you from the property, this is one of our takeaways, the landlord has to take you to court. Your landlord cannot come and, turn off the landlord says, I want you out. They can't try to force you out by shutting off your utilities or changing the locks or taking the doors off or sending the goon squad to try to scare you away. They have to take you, those are all violations of civil law that you can sue them for. They have to take you to court. There are 3 types of lawsuits that they can file to get possession of property back: unlawful detainer, rent and possession, and expedited eviction. The tenant's age and health are not an issue, and it's not that our judges don't care about the circumstances that led you to being behind on rent or being unable to move at the end of your lease. It's not that they don't care, it's that the law is, the statutes that give rise to these causes of action are very, very clear. These are not factors that can even be considered. A written notice from a landlord is, just for terminology, the sake of using the proper terminology, a written notice to vacate from your landlord is not the actual eviction. The eviction is, by definition, the lawsuit to remove you. Okay, next slide.
One question.
Yes, ma'am.
Can you explain the difference between those 3 basic types?
Well, we are gonna do that right
Oh,
now.
okay.
So rent and possession is the most common lawsuit that I see. In order to sue for rent and possession, the landlord only needs to allege in their petition that you are a day late or $1, well, that says a penny. Let's allow for inflation. You're a day late or $1 short, right? The landlord isn't required to give you notice of their intent to file rent and possession. They can literally, the day after your rent is due, if it's not paid in full, they can file a petition. Written notice is not required. In this lawsuit, the landlord is not recovering damage to the property, okay? So, that's not a part of this cause of action. It's simply, is rent paid, is rent not paid? It goes on a special docket in the court, which we call the rocket docket, because rent and possession actions move faster than any other action in associate court. The statute says that you have to have a court date within, I think it's 18 days, and then it has to be set for trial at the court's earliest possible date. In Greene County, because of, just the court's backlog, we're looking at from the time a case is filed until you get to that first court date. It's actually, as a practical matter, pushing closer to between 3 and 4 weeks. And then they'll set it for trial within a week of that date. They do, like I said, they move quickly. You do not have the right to a jury trial, okay? Next slide. You can, as the defendant, the tenant in a rent and possession case, you can raise certain defenses or affirmative defenses. Now, something about affirmative defenses that is really important to know, in order to raise an affirmative defense, you have to put it in writing and file it with the court before your first appearance date. So when you're sued, you're gonna get a summons that says appear in front of this judge on this date at this time. If you have an affirmative defense, you have to notify the court by putting it in writing and filing it with the clerk before that hearing time. Now, if you go to the clerk 20 minutes before you're scheduled to appear in front of the judge and you file it right then, that meets the statute, that's fine. But if you wait until after you've talked to the judge, you've waived your right to raise any affirmative defenses. Now, the straight defenses to a rent and possession are, of course, that you've already paid the money, and that's why those receipts come in real handy. That's the whole point of a receipt, is to be able to prove to a third party what you paid and when you paid it. Another defense is that the landlord has made an unlawful demand for rent, so they've notified you of an increase in rent that they don't have the right to do. Like, let's say it's in the middle of your lease term. Your lease goes from April 1, 2025 to April 1, 2026. In July, your landlord says, hey, I'm planning a trip to Cabo or Chicago or something like that, so I need to raise your rent by $100 a month. That's an unlawful rent increase because it's in the middle of a lease term. If they sued you for not paying that increase in rent, this would be your defense, is that they were demanding rent that they were not lawfully entitled to collect. Those are defenses, you don't have to put those in writing before you go to court. Only these affirmative defenses have to be in writing, and that is breach of implied warranty of habitability that we talked about, that there's a condition that poses a risk to you, to your health or safety. Breach of contract, that the landlord actually breached the lease before you stopped paying rent. Or, and I throw this one in, cause my Pollyanna heart just really believes that one day it's gonna be successful, but that the rent that's being charged is inequitable. I've yet to see it work, but I still try it. Inequitable just means that it's unfair. Again, I haven't seen it win at court, but one day it's gonna work. Basically the way this works is if you allege one of these affirmative defenses, then you'll put on your evidence and show how the landlord's actions damaged you. The judge is gonna do the math and say, okay, this is how much is proven to be behind in rent, this is how much you proved were your monetary damages. If your damages are greater than the amount that is owed in rent, then you're gonna win the case. So that's why affirmative defenses are handy. Go ahead. The second lawsuit is unlawful detainer. Yes ma'am.
I just have a quick question. So I had an individual, that I was working with that mentioned that they, and this was kind of an ongoing thing with the tenants in this particular complex. But then when they would request that something be fixed, they were being sent a notice of increase, for the next month or so.
Okay.
They would, basically to discourage them, and she told me before we even, were trying to acquire funds to assist her. But anyway, she told me he's going to raise my rent.
Okay.
If we have any dealings with him, because it just inconveniences him.
Okay.
So things have been inconvenienced, he was looking at raising the rent, and sure enough, she brought me back a notice that he was trying to increase the rent the next month.
Okay.
So,
So just to repeat, the issue is there's a tenant who knows, and in fact it did happen, that whenever the tenant makes a maintenance request to the landlord then responds with a notice of increase in rent. And the question is that legal, right?
right.
Sometimes yes and sometimes no. A landlord, if the lease is for a written term, again, April 1 to April 1, that would be an illegal rent increase. If the lease is a month-to-month tenancy, so it's not for a specified term, it goes from month to month to month, then the landlord can increase rent for a good reason, a bad reason, or no reason at all. And they can do it in retaliation for inconvenience or whatever. The only limitation on that is that the notice of increase has to be done, it has to follow a certain procedure, and that is, just like terminating a month-to-month lease. Either side can terminate a month-to-month lease by giving notice in writing, that the lease is going to terminate, or that the rent is going to increase on a regular rent paying day that is no less than 30 days from the date you received the notice. So what that means is you have to have one full rental period between the date you get the notice and when the change takes effect. Now, our courts have said that if a written notice, and this is usually comes up in the context of termination of a lease, but it also applies to rent increases. If the written notice is insufficient, a short notice, if you will, say, for example, gives notice on April 2nd, that rent is gonna go up starting May 1st, that's a short notice. Those are what we call void ab initio. They are void from the get-go, they have no force or effect, it's like they never occurred. A savvy landlord would know that by now, and so if the rent increase notice is delivered on April 2nd and says your rent is gonna go up starting June 1st, that is illegal. That meets all of the requirements that they have to hit, and so it would be enforceable. There's no, anti-retaliation provision in landlord-tenant law. Landlords can make their decisions for a good reason, a bad reason, or no reason at all. The only thing they can't do, and this may be an added little layer to that, they can't make a decision based on an unlawful reason. There are, and that's under the Fair Housing Act. The Fair Housing Act prohibits any type of discrimination based on, protected status, and that's disability status, age, sex, race, national origin, religion. So, I'm like law nerding out here, cause I'm thinking, if the maintenance requests relate more to an accommodation for a disability as it's defined under the ADA, and the landlord raises rent in response to that, that would be discrimination based on disability status, so that would be prohibited. But unless you meet that special little niche, then there's no anti-retaliation. Okay?
And unfortunately, he knew all of that. I mean, like, this was,
Yeah.
he operated correctly, all of that. Yeah, she was month to month, he gave her everything and all of it.
Yeah, it's, if I had any sway, or if I could make one change to the Missouri statutes on landlord-tenant law, is I would throw in some type of anti-retaliation provision, but unfortunately, it's not there right now. Okay.
Thank you.
Any other questions on rent and possession? Okay.
You had one.
Yes, ma'am.
You said that, if for raising rent, you had to give them a 30-day notice. What if it's a week? Would it be a 1 week notice?
Well, I'm gonna think about how the statute's written. I think so, because the way the statute's actually written is, it's presumed, unless the lease specifies differently, it's presumed to be month to month, so that's what most of them are. But there are some short-term leases, you're right, that go week to week. So yeah, so the way the statute is written, I believe it says a regular rent-paying term. So they have to give at no less than a regular rent-paying term's notice, I believe.
So that'd be a week?
If
A
your
week's
rent,
notice
if your
is
rent
what
is
you mean.
paid, you know, say your rent is due every Friday and you're paying by the week, that is possible. Although, if you give me your contact information, I can look it up and I can get back to you, cause I'm not 100% sure about that, I've not been confronted with that, so. Yeah, before I leave, give me your contact information, I'll look into that and get back to you. Anybody else? If you have any specific questions you want me to address that we don't get here, I'll let you guys have, you know, my contact information. Feel free to reach out to me, or give me your contact information and I can send you materials. Okay, so I'll get you later.
Okay.
I'll brief you on that at a later date. Okay.
Circle back.
That's right. Okay, so unlawful detainer, that is the second most common lawsuit that I see. Unlawful detainer exists when somebody has a right to possess the property, but that right has now ended for whatever reason. It's ended because the lease has expired. It's a 1-year lease and the tenant held over without the landlord's permission. Or, you know, the tenant violated the lease and the landlord declared the lease terminated. So for whatever reason, if you had a right to be there, but you don't have the right anymore, the landlord can sue for unlawful detainer. If they win, all they have to do is, again, prove that you don't have the right to possess the property anymore. The consequences are the judge will give a judgment for possession of the property, just like in rent and possession, but they'll impose a penalty of 2 times the regular rent for the property for the period that you were unlawfully detaining. So if you held over for 2 months, you're gonna end up paying 4 months worth of rent. So it can get expensive. Again, these cases move pretty quickly, but the difference is that and don't ask me why, but with unlawful detainer, you actually have the right to request a jury trial. So, that can delay the proceedings a little bit, but again, by statute, the statute says that the court has to try these at the earliest available date, so they'll move your case ahead of others that are already on the schedule, just to accommodate that statute. Next slide. Your defenses in unlawful detainer are that your right to possess the property was not terminated. Usually that happens if your lease is terminated for an alleged breach of the lease. If you can prove, if your landlord can't prove that you actually did the thing that they're saying you did in breach of the lease, then you'll win. That is the only defense to unlawful detainer. There are no affirmative defenses allowed in an unlawful detainer case. Next slide. The third one, and I don't see this as often, is expedited eviction. An expedited eviction, it moves along the same track as a rent in possession case, so it's on that rocket docket. The landlord doesn't have to give any notice that your lease is being terminated. Your first notice can be the filing of the petition, but they can only get it in limited circumstances, and that is if you let somebody into the property that has already been barred from the property via an expedited eviction. If there's drug-related criminal activity, or it's not up there, or if there's activity that you're doing that poses a risk of imminent harm to another tenant, or you're causing property damage that is estimated or likely to be equal to, I think it's 6 months rent, the total is 6 months rent. So if you're committing waste on the property, damage to the property, they can get an expedited eviction. They don't have to prove there was a conviction or an arrest of, when they're relying on criminal activity. But they do have to prove the criminal activity actually occurred. The landlord or the prosecuting attorney can bring this type of eviction. There's some question as to whether the leaseholder can remove another tenant within their leased space under this statute. That's not been clarified by our courts, so I'm willing to try it. But so far we haven't gotten a lot of guidance on whether another tenant can bring one of these actions to remove a problematic or threatening co-tenant. The defenses are kind of complicated, but they kind of come down to when it's drug-related criminal activity. If the defendant can show that between the time they were served and trial, they were admitted to certain types of rehab programs. Those are about the only defenses to these types of evictions, other than, of course, proving that the alleged behavior didn't actually occur. We don't see these very often, but when they do happen, they happen very quickly. Next slide. Okay, so that's all the lawsuits the landlord can bring against you. Let's talk about what you can do to your landlord. If your landlord tries to do a self-help eviction, then you can sue them for damages, meaning the landlord has to pay you money. A self-help eviction, also called forcible entry, that's the legal term, that occurs when the landlord takes some action that the lease doesn't authorize them to do for the purpose of forcing you out. So, like I said, removing doors and windows, changing locks, shutting off utilities, sending the goon squad. All of those can be the basis for a forcible entry lawsuit. If this is happening, my recommendation to my clients is first call your local law enforcement. In Springfield, they've been really good about responding to these and telling the landlord, you need to leave. If the tenant, even if the tenant is, a year behind on rent, the police don't get involved in that. The question is, are they a tenant? Yes. Landlord, you have to leave or else we're gonna arrest you for trespass. They've been pretty good about that. So call them first and then call us second. Go ahead. When you get a judgment for possession, which of course, nobody wants that, but in the rent and possession, unlawful detainer, or expedited eviction, the common remedy, I should say, is judgment for possession that restores the property back to the landlord. Before it's effective, it has to be served by the sheriff or the sheriff's deputy. So if the landlord goes and gets their judgment, they can wave that paper around all they want. It doesn't actually remove you from the property until it's given to the sheriff to serve the execution. What the sheriff can do once they're serving it is they're required to remove only the named people from the property, or the people named in the judgment, but landlords will often name Lee Doe, John Doe, Jane Doe. If anyone with the last name of Doe is named, that gives the sheriff or the deputy authority to remove any other adults in the property, okay? Once that happens, the sheriff will come and they'll escort the people out of the house. The moment you cross that threshold with the deputy, you no longer have the right to possess the property, and if you re-enter, you're committing trespass. All of this stuff left behind, if stuff is left behind, it's still yours, but you don't have the right to go in and get it. So the landlord can do pretty much whatever they want to with your stuff, except they can't keep it and they can't intentionally destroy it. What they can do is, take your flat screen and chuck it in a dumpster, and if it gets damaged, oh well. They're not required to keep your stuff safe. They're not required to handle it with any measure of care. They just can't keep it. They usually put it out on the front lawn, and if neighbors come along and sift through it and take their favorite stuff, then you have no recourse against the landlord. Oftentimes they'll also just put it straight into a dumpster. Next slide. If the sheriff is coming to execute on a judgment, some tips are, first, remove any valuable or irreplaceable items first. I call it the move out triage. First, I recommend that people pack a go bag with their medications and their most important papers in it, so that when the deputy shows up at the house, and it sends you out the door, you have a bag that you can grab to take with you. Because you won't be given an opportunity to pack a bag. Then start, what's your most irreplaceable, valuable stuff, get it out, get it off property, and then kind of move through your stuff from most valuable to least valuable. Because there's no guarantee of when the sheriff is gonna show up to actually remove you. Don't have anything illegal on the premises. The deputy is not there to do a search of your stuff, but if there's evidence of any crime or criminal activity, they have the right, if it's out in the open, they have the right to arrest you for that. And don't engage with your landlord, no matter how emotional or heated it is, and don't resist the police. Those are the tips for if an execution is happening. Go ahead, next slide. There is a website I want to draw your attention to. It's called motenanthelp.org. It's got a lot of good information, but most importantly, the best part about it is it does an online interview, asks you a series of questions, and then it will pump out for you a lot of the pleadings that you will need if you're sued. So your affirmative defenses, counterclaims, it will prepare those for you and tell you how to file those. So this is really a great resource I would encourage you or your clients to utilize. And I think that's the last slide. I think that's it. All right, thank you. Any questions? I feel like I kind of flew through that. Anybody have any questions?
Just, which one, you may have already covered it, but which, what would you do about a squatter? Like somebody just, we have an empty property and they've taken over the property.
Well, I wouldn't do anything about a squatter because that's outside of the scope of what legal services do. But I can tell you, there is a new statute. It's a squatter statute. I don't know enough about it because, again, it's outside of the scope of what I do. But it allows for what is essentially an ex parte type procedure to remove somebody. So, I don't even know the number of the statute, otherwise I'd give it to you. But you can, under this new statute, you can, a property owner who has a squatter, which a squatter is defined as somebody who never had any right to be on the property. So not somebody who was a tenant who held over or was given permission to stay and then that permission was revoked. It's somebody who literally never got the okay to be there. Then you can file for removal of the squatter. The court will grant that upon review and get an order of removal, and then we'll set it so the sheriff will come and remove the person without notice from the property. And then within some prescribed period of time, which I don't know what that is, then the court will hold a full hearing so where the alleged squatter can come and offer up whatever evidence that they have that they did have the right to be there. I think if you Google like squatter statute Missouri, like the word squatter statute Missouri, it will talk in more detail about that and the specifics of how to get that. Anything else? Yes, ma'am.
On the implied warranty of inhabitability.
Yeah.
Does that only apply to the safety of the physical property? Would that apply to if others there, if it's not a safety net, if somebody has a standing order, or something like that? Is that included?
No.
Okay.
It's really the physical condition of the property. What you're talking about, because I've had that circumstance where, if I understand, the question was, is implied warranty of habitability only applied to defects in the physical structure of the building, as opposed to dangers imposed by other people. I've had this situation where I've had a client who has a neighbor who was harassing them and threatening them, and we didn't get, quite frankly, there's the Missouri domestic violence statute, which applies to all residential leases, or if it's a public housing, federally funded housing, the Violence Against Women Act applies. And that provides some protection to the tenant that will allow the tenant to get out of their lease. And under the Violence Against Women's Act, the landlord has an obligation to make available to them, if they have something, for this tenant to transfer their lease from this property to another.
But it doesn't allow that person to get a threatening person out.
Right. Now, one thing we've considered doing, and we haven't had the right facts come to us to file this, but if the lease between, I'm gonna give them names to make it straight, but let's say Mary is living in apartment A, and Beth is living in apartment B, and Beth is harassing and stalking Mary. Let's say that Beth and Mary both in their lease has some provision that says, that one of the conditions of the lease is that, you'll not infringe on the rights of others, you won't be a nuisance, yada, yada, yada. If the landlord has some grounds and has knowledge of the behavior of Beth and does not enforce the terms of the lease between landlord and Beth and remove Beth, thereby removing the danger, it is possible, I've never done it, but it is possible that Mary could then sue the landlord for breach of the covenant of quiet enjoyment. I didn't really talk about it in the presentation, but that is one of the implied rights that tenants have, is that you'll be able to quietly enjoy the property.
But does the landlord have any legal right to remove that?
Well, you can only sue for breach of covenant of quiet enjoyment if the landlord has a contractual.
I'm getting the names mixed up, the one that was causing the problem.
Yeah, Mary, the one who wasn't causing the problem, could only raise this action if she can show that the landlord had the right and the capacity to remove Beth and didn't.
Okay.
That's gonna be an essential element of that, but I've never done it. I'd like to. If I get the right fact pattern that comes, it would be interesting to see how that plays in court. But it's definitely worth a try, cause we have that a lot, come up more often than I'd like. Yes, sir.
So what are the average costs for like legal fees? Say that you were like dealing, you were a tenant and you were facing like an unlawful eviction. How much would that like cost someone to like to acquire like legal representation?
Sure, at legal services, it doesn't cost anything. Our services are provided free of charge. We're funded by different grants and funds specifically to do this work for people who meet certain income thresholds. I think it's 125% of the poverty level is the maximum, income level that we have. But we also have grants that allow us to do work for people who fall in certain age categories as well, regardless of their income. If you were just gonna hire somebody, let's say you didn't qualify for our services, we're the only game in town, folks. There's nobody else that I know of who's providing free tenant services here in Springfield. So if you didn't qualify for us and you had to hire somebody on just a private bar attorney, I honestly have no idea what they would charge. It could be anywhere from $150 an hour to $300 an hour. So that's why most tenants don't hire attorneys, is because if they had the money to pay the attorney, they probably wouldn't be in that position in the first place.
Right.
There is, just so you know, Springfield City Council is considering a bill that guarantees a right to counsel to all tenants in landlord, tenant cases. I'm not sure where it's at in that process.
So, that's going to be, hopefully that'll be presented to, the Community Involvement Committee after, they pass their resolution for their pilot for the rental inspection program.
Okay, so you know more about it than I do.
Yeah,
You should be up here talking.
I'm with Springfield Tenants Unite. so
Oh, okay.
I was just curious, cause like I don't know anything more about like the legal part of everything, just because like, as you know, like we're like 60% of like Springfield's like low income like tenants, and like we don't know like how to like even approach like to get legal services when it comes to like issues like this.
Yeah. Well, again, I mean, not that I'm, trying to drum up extra business, but, you can, tenants, again, who meet that income threshold, they can apply to us for services. And unfortunately, the truth of the matter is, we don't have enough attorneys or enough funds to represent everybody.
Right.
I don't remember what the numbers are about how many applications we reject just due to lack of resources. But, doesn't hurt to ask. So you can apply online, or someone can apply by phone, and just see if you can even get in.
Right.
So that's one option. If right to counsel passes, then, that will open up availability of attorneys to everybody, which would be great. As far as the cost of an attorney, I thought your question was going, which is a great question, so I'm just gonna give it to you. What is the average cost to a landlord for an eviction? That's important information, because most leases say that if your landlord has to sue you, then they can add on their attorney's fees. So what I'm seeing right now, as far as attorney's fees for a very straightforward rent in possession, 2 months ago, it was $500 is what they would just tack on to the judgment. It varies by law firm, but I'm seeing those go up now, to about $1,000 is what they're asking the court to add on for a simple rent and possession. If it goes to trial, that actually increases the fees the landlord has to pay to their attorney, which results in a higher attorney fee award against the tenant. So, yeah, we're trying to figure out how to address that, cause I think that's a bit excessive, but, yeah, if they can prove that they had to pay that to their attorney, the landlord can recover it from the tenant, so. Yes, ma'am.
I'm just, cause I've never been down that road, thankfully, but, so how do they recoup that if they don't have it? I mean, like, what is the recourse for them if the tenant doesn't have that $1,000 bill? What happens from there?
Well, what happens is, this is a dollar amount that's gonna go into that judgment. So when the judgment is written by the judge, he's gonna say, the judge is gonna make a finding of fact as to how much you owe, or how much the tenant owes in unpaid rent, fees, damage, whatever. And then that'll end up with a dollar amount, and the judgment will award that amount to the landlord. Now, we don't have a debtor's prison system in the United States, so they can't force the tenant to pay, the landlord can't reach into the tenant's pocket and take the money out, right? What they can do is once they have a judgment, they can garnish wages, if there are, but of course those wage garnishments are limited by, they're limited to recovery of 25% of the, I believe it's the net of the debtors of their wages, unless the debtor is head of household, and then that limits it to just 10%. And then there's another limitation, that amount can't exceed, the amount that the debtor has to be able to take home has to be equal to 30 times the federal minimum wage. So the garnishment can't reduce the take-home pay down to less than that number. So that's one way that they can get the money. They can seize bank accounts, they can seize other assets outside of like the household exemption. Most landlords don't try to take assets, they usually go after wages. There's some income, social security benefits, whether they're the retirement benefits, survivor benefits, or disability benefits, are exempt from garnishment. Not only are they exempt from garnishment, but the bank account that they go into, as long as it's not commingled with other funds, that bank account is also exempt from attachment. So that money is safe. That person would be basically judgment proof, which is why the third way that they get money is in this market right now, when we have such a shortage of available housing. What we're seeing happens a lot is that when a tenant applies to a new landlord, that landlord does the reference check. There are a number of landlords that will accept tenants who have evictions on their record, but of those landlords, I believe the majority of them require proof that you've either paid off everything you owe to the previous landlord voluntarily, or that you have an ongoing repayment plan with them. So, all the landlords kind of agree, not all of them, but most of them agree that, they won't accept a tenant that still owes another landlord money. And so that's how ultimately they end up getting paid, is, tenants have to be able to rent someplace else. Okay, and if they can't, then the market, the supply of the market that's available to them, especially if we're looking at lower cost housing, it gets pretty sketchy. So, yeah. Any other questions? Come on, I know you've got one more. You got one more in you.
No,
Nope,
this is great.
I covered them all.
Very informative, but I did see a hand back there.
Oh, yes.
Okay, yeah, quick question.
Yeah.
Okay, so this pertains to, the part where you were talking about the max is 2 months 2 times the monthly rent in
Of
deposit.
the security deposit,
Yes.
yeah.
So, not gonna call out any particular property managers, but let's say that they say, okay, well, our deposit is $850, your first month's rent is $850, but if your credit score is a little lower, then we double the deposit, so now it's $1,700. Oh, but we also have a $500 administrative fee.
Mhm.
So how do they, because they're calling it an administrative fee, is that how they can get away with charging more than the 2 times the rent?
Yes, so the security deposit is solely, it's a fund of money that a tenant pays as security for, that they're gonna do everything that they're supposed to in the lease, and that's why the security deposit has to be refundable. An administrative fee is not refundable, so it's outside of what the statute that covers security deposits, it's outside of what that covers, so.
Is there any cap on what that fee can be?
No.
Cause I've seen some as high as the monthly rent also.
Yeah, not that I'm aware of.
Okay.
There's also, what do they call it? It's not rehabilitation fee.
Restoration.
Restoration fee,
yeah.
thank you. So there's the restoration fee, right? And what the courts have said is if it looks like a duck and it walks like a duck and it quacks like a duck, it's a duck. So if they're treating that fee, that restoration fee, like a security deposit, it's refundable, even if the lease says it's not refundable. You know how I said that illegal terms in a contract, we just pretend they weren't there, the court pretends they weren't there. It's the same thing with saying a restoration fee is non-refundable. However, if the lease says that, if the restoration fee is just a flat fee for, you don't have to clean the apartment, you know, the restoration fee is gonna cover that, then it doesn't matter if you left the place spotless, you're not getting a penny of that back. So that's how they can go about keeping that whole fund, is by calling it a restoration fee and not tying it to any obligation that you have in the lease. But it's tied to any obligation of your lease, like it's intended to restore the property, to repair what you damaged, then it becomes a security deposit, even if they call it a restoration fee. Yeah. Yes, ma'am.
I do have a question. It is about a third party, for your security deposit.
Okay.
When we have moved into our place, we qualified for $500 deposit.
Okay.
And it was going through a third party, because when we applied for the house, they said, it goes based on your credit, that's what your security deposit is. Now we're here a year later, and they said that that's expired, and that was insurance.
Now that we're gonna renew, because the years that we were gonna renew, now they're trying to give it to us, make us pay $500 again.
Again,
But
okay.
then she said, when I talked to her, I was like, how do you know how that happens? And then she said, well, we can talk to the owner and ask him to take off $500, but then we would need to pay this $795, like, right away.
Okay.
What was the original deposit?
I've never
Yeah.
heard of that before.
Right,
What,
we are,
in order to really know what's going on, I don't suppose you brought a copy of your original lease or receipts with you tonight? Oh, well, darn. I would need to see those, I'll give you my contact information and we can talk about this tomorrow. I've never heard of that before. In my head, I can kind of envision a way that a sneaky landlord could get away with that, but they'd have to do it a specific way. If they didn't do it the right way, if it's a security deposit, you know, you
well,
only
it's
pay.
almost the same nature as what the
Yeah.
individual was.
Well, what we really wanna look at and what is key, to the extent I haven't expressed this before, and this is an important takeaway, the black and white lettering of your lease is really, that's like the first place that we look, and, because the landlord wrote it, and you don't really have the opportunity to negotiate those terms. The court's gonna read those strictly, And if there's any ambiguity, they're gonna interpret it in favor of the tenant. That's what they're supposed to do anyway. So we always look at the language of the lease. In order to get away with that, they're gonna have to be real clear about the language that they use. So, saying it's in the same nature as the restoration fee, that doesn't give me enough to go on, because it really matters like what was the exact wording that was used. So I'd wanna see that
Yeah, they
lease.
said it was, the deposit.
Yeah,
So now I have a feeling now it's
It's
just not really a
something-
deposit.
Well,
They're
see-
gonna call it something else, I just.
Well, if
We
it-
are
but-
ready to move.
okay, so, yes, I mean, every time you renew your lease, it's a new lease. They could charge a new deposit, but they'd have to return your old deposit too.
Right.
So that's what I wanna look
So
at.
why would you make
Okay.
me give a new deposit if you came in my home
Yeah.
three times and said it's fine?
Unless there was damage that was done that they repaired and already
No, we just
exhausted that.
renewed the lease.
Okay, so, yeah, I'll make sure you have my contact information and you can get me your lease and we can look at that together, and figure out kind of what's going on.
Thank you.
Anybody else?
I gotta say one thing about the administration fee.
Yeah.
That they mentioned about the scenario that was given about the additional deposit, double deposit, and all by the way of a $500 administration fee. I totally agree with what you said. The only thing about that though is if they double deposit, then said they have a fee, they gotta charge the fee to everybody, the administration fee. You can't pick and choose on who you charge an administration fee.
I would disagree.
Okay, because you can't, federal fair housing won't allow you to offer one thing and someone else of the
If
same
it's
kind.
federally funded or subsidized, but on the private market, so that's a fair distinction.
So that's the thing, not knowing the situation outside what they said.
Well, in that situation, that company does always charge a single deposit and always charges
Okay,
the.
so they're charging everybody the same thing.
Yeah, that's
Okay.
okay.
It's just that.
So they know it up front is
Yeah.
the thing.
Yes,
They know,
you know
everybody
up
knows
front.
it.
And if it's a private landlord, meaning not federally funded, they absolutely can pick and choose who they charge an administrative fee, as long as they're not basing that decision on protected status. So you can't charge an administrative fee to every black family that applies, for a tenancy and not to the white families. But you can charge an administrative fee to Sarah over Mary, as long as the basis for that decision is not age, sex, race, national origin, religion, or disability. Okay? Anybody else? Did I answer your question?
Yeah.
I mean, I think it was kind of a
She
collective
did.
group effort.
Well, they said they charge everybody. I'm like, okay, well then it's not a big deal.
Yeah. Any other questions? All right, well, on the table, when you guys came in,